the defendant is a significant risk to the public as well as to herself, because she cannot stop drinking and then operating a motor vehicle. It just seems at this point she is fortunate that she hasn't taken somebody out. Or before the court on a misdemeanor complaint that alleges that on or about April 12, 2026, location of Gulfside Road near Washington Road, that you committed the offense of operating while intoxicated or impaired, second offense. You understand that, ma'am?
Yes, sir.
That is a misdemeanor punishable by up to 1 year in jail, $8,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized or forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, ma'am?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
Public defender case.
Ron Brown appearing on behalf of Ms. Henderson. Waive reading stand. Request adjournment.
Defendant every waive from a reading standing mute. The court will enter a not guilty plea. Pretrial will be set for
June 17th.
June 17, 2026, 9 a.m. As to bond.
May I approach, Your Honor, with the prosecutor?
I would also ask to approach, Your Honor.
Yes, Your Honor.
What did you?
Just listen.
Record should reflect we've had an extensive bench conference in this case, trying to figure out the defendant's record. My understanding, first of all, that there is, as to her bond, that there's a prior offense in 2022. There is a current pending drunk driving from I think it was 2025.
Correct.
2025. Out of that, and this becomes important, that case is still open. There is also, from, I believe, that offense, an implied consent violation. And out of that implied consent, her license or driving privileges in the state of Michigan were suspended from the date of, I just want to make sure I have the dates correct, but
July 20.
From July 12, 2025 to July 11, 2026. So as we sit here today, her driving privileges are suspended. I then have that. So in April of this year, this alleged offense, she was issued a 625G, but she cannot drive on that 625G because of the implied consent. She had no license at that time. At the time that this offense allegedly occurs, she also then has an open drunk driving case out of another jurisdiction and has the prior. And then she is here allegedly in this case with a 0.235 blood alcohol level.
Judge Simpson has just identified why this bond hearing is far more serious than an ordinary misdemeanor arraignment. The new charge remains an allegation, and the defendant is presumed innocent, but bond decisions allow the court to evaluate documented history, pending cases, compliance concerns, and potential danger. Here, the alleged 0.235 blood alcohol result is not being viewed in isolation. The judge is connecting it to a prior offense, an unresolved 2025 drunk driving case, an implied consent suspension, and the fact that she allegedly drove while her privileges were already suspended. That distinction matters because bond is designed to manage risk before trial, not punish someone in advance. The defense must now convince the court that strict conditions can control that risk despite what appears to be repeated conduct. Notice how carefully Judge Simpson confirms the dates and license status before hearing the bond arguments. He is building a factual record that can support whatever conditions he ultimately imposes. Would employment and responsibility for a 4-year-old child outweigh this pattern for you? Or does the combination of a pending case, suspended privileges, and the alleged alcohol level make ordinary release conditions inadequate?
Brown, is there anything you want to say on behalf of your client regarding bond before the court fixes bond?
Your Honor, she's employed at General Motors in Lansing. She has a 4-year-old daughter that she cares for. She works from 10 p.m. until 6 a.m. I've mentioned sidebar that she does have a prepaid, pre-planned trip before all of this. And I'd ask the court to consider a reasonable bond in this case so she can save her job and take care of her 4-year-old. A scram, monitoring device.
Anything from the people?
Your Honor, not to recount everything that was discussed at the bench, I have significant concerns for this defendant's ability to remain sober or compliant with her bond conditions. I also have concerns about her returning to court at future dates, given the multiple warrants and given that she knew that she had those warrants at the time of this offense and told the officers essentially she was on the run from those warrants.
This is the turning point because the prosecution has now attacked both pillars of the bond analysis: public safety and likelihood of appearing in court. The defense presented legitimate stability factors: employment, a young child, and the need to preserve her livelihood. But those arguments become less persuasive when placed against alleged repeated impaired driving, multiple warrants, and an admission that she was effectively avoiding them. The prosecutor is strategically asking for more than alcohol monitoring. Scram addresses alcohol consumption, while GPS addresses location and potential failure to appear. Together, those conditions target two different risks. There is also an important procedural detail. Some information discussed at the bench is being kept off the public record because the prosecutor describes it as private. Judge Simpson can consider properly presented information while avoiding unnecessary disclosure, but his ultimate ruling still needs an adequate public explanation. Did you notice that the defendant's personal circumstances were not directly challenged? Instead, the prosecution argues that those positive factors have not produced reliable compliance. That is a much stronger courtroom strategy than simply portraying her as irresponsible. Would a lower bond with electronic monitoring adequately protect the public, or does the alleged statement about being on the run justify a cash requirement as well?
For reasons discussed at the bench, which again, some of those are private, I'm not going to get into on the record, as well as those reasons, I would ask this court set a relatively significant cash surety bond with, if the defendant were to post that bond, scram and GPS tracking tethers in case she does fail to appear, we can at least know where she is at that point.
However, standard conditions, including no assault behavior, possession of any weapons, firearms, ammunition. It will also indicate that the defendant is not to possess and or consume any alcohol, recreational marijuana, or any illegal drugs. You do understand that, ma'am?
Yes.
I'm going to say I consider, given all of those circumstances, that the defendant is a significant risk to the public as well as to herself, because she cannot stop drinking and then operating a motor vehicle. It just seems at this point she is fortunate that she hasn't taken somebody out. She's a .235 at this instant, with a pending drunk driving and a prior, all occurring within the last 7 years. She's not supposed to be driving because she doesn't have a license, because she didn't take a test on one of these occasions. And the only license that she would have would be a 625G permit, which she can't drink and drive on. She's not supposed to be drinking and driving. Since I consider this defendant to be a significant risk to the public, And we can try to figure it out. Her bond is set in the amount of $1,000 cash surety bond. The defendant is remanded. She must be placed if she posts that bond on a scram tether and a GPS tether prior to her release. Defendant's remanded.
Court date?
Thought I gave you one. June 17th, 9 a.m.
Thank you.
Location track.
Location track.
Judge Simpson ultimately sets a $1,000 cash bond, remands the defendant until it is posted, and requires both scram alcohol monitoring and GPS tracking before release. The ruling reflects a layered approach rather than outright preventive detention. Cash secures release and reinforces court appearance. Scram monitors the specific alcohol-related danger, and GPS helps address the prosecutor's concern about warrants and potential flight. Standard prohibitions on alcohol, recreational marijuana, illegal drugs, weapons, and assaultive behavior further define what compliance will require. The judge's reasoning rests on accumulation. A prior offense alone might not establish an immediate danger. A pending drunk driving case alone would still require careful assessment. But when those facts are combined with suspended driving privileges, the alleged 235 result, and the claim that she knew about outstanding warrants, the defense's employment and childcare arguments cannot neutralize the perceived risk. Those circumstances explain why the pre-planned trip received no meaningful weight. Convenience is secondary when the court believes public safety is threatened. Importantly, this is not a finding of guilt on the new charge. It is a pre-trial risk management decision based on the information available at arraignment. The broader lesson is that judges evaluate patterns of compliance, not merely the label attached to the newest charge. Do you believe the monitoring conditions were sufficient, or should the court have imposed an even higher bond? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.